Lesson.
Yes, Your Honor.
The costume on this
Yes, Your Honor.
is 2560811. You are Miss Morales Vega.
Yes.
Ma'am, you're charged with prostitution. You're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, an officer was working in an undercover capacity in plain clothes when he entered a sexually oriented club and sat down at a table. The officer engaged in conversation with the defendant. The defendant agreed to participate in oral sex with the officer for a fee of $400. The officer notes that the conversation was recorded. The arrest/enforcement team detained the defendant and took her into custody without incident.
Ma'am, I'm going to find that there's probable cause to go forward.
Okay, this is straight out of the undercover playbook, plain clothes cop, suggestive conversation, $400 deal, and a recording to seal the case. But here's the legal hot potato: is this proactive policing, or could it be flirting with entrapment? I want to hear your take in the comments.
I'm ordering you now as a condition of your bond for participation is lifetime behavior. If I find that you do, I will revoke your bond and put you in custody, ma'am. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes, sir.
Can I provide you a lawyer today? Would you like a lawyer?
I have an attorney. Yes.
Are they supposed to be here today?
Not today.
Sí, pero no dijo como que él no tenía que presentarse con ella.
She said she hired one, but he's told her that he did not need to be here today.
Person hasn't filed any documents. I don't know. I mean, if you would like, I can give you more time. I'm happy to give you a court-appointed lawyer today if you want one. You tell me what you'd like to do. I can, reset you and give you more time. Normally, lawyers file documents.
Give me another take.
Okay. Like I said, if you want a free lawyer, I'm happy to give you one today. So if you have problems when you're out there, you can come back and we're happy to give you one.
I have one.
Okay, that's fine. I just hopefully they'll come here for the next setting. I don't know. For now, I'm going to have you go to Victoria, sign a reset. After that, I'm going to have you take your seat in the jury box while we get your bond conditions. We're going to have you sign them, and after that, you'll be free to go. Do you mind filing your conditions, please?
Absolutely.
No engaging in this. You are Mr. Rosabal Matos. See.
Yes.
Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge. On April 19th, 2025, in Harris County, Texas, an officer observed the defendant run a red light on North Shepherd Drive. The officer then observed the defendant's vehicle fail to drive in the designated lane, striking the raised median and causing his tire to go flat. A traffic stop was conducted. The officer made contact with the defendant and observed the defendant to be the driver and sole occupant and to have bloodshot eyes and slurred speech. The officer could smell an odor of alcoholic beverage emitting from the defendant's vehicle and from his person upon his exit from the vehicle. Officer Castrejon spoke to the defendant due to the defendant being a Spanish-only speaker.
Waypoint 15. A back of .161? That's double the legal limit in Texas. And yet, no prior record. Here's the moral dilemma: do first-timers like this deserve a harsh sentence to set an example, or a shot at rehabilitation? This is where justice gets subjective.
The defendant admitted to consuming one beer. Standard field sobriety tests were conducted. The officer noted a 2 out of 6 on the HGN, but also noted that the defendant would not follow the stimulus during distinct and sustained nystagmus at maximum deviation. Therefore, the officer was not able to observe the clues on that basis. The officer noted a 3 out of 8 on the walk and turn and a 3 out of 4 on the one-leg stand. The DIC was read on a recording in Spanish at the Joint Processing Center. The defendant consented to a breath test. The 15-minute waiting period was observed, and the breath test came out to a .161 and a .153.
Any prior DWIs and a license?
No prior DWIs, Judge. I'm checking on the license.
Que si tengo licencia.
Find sufficient probable cause.
Voy a averiguar que sí hay
Case.
razón juratoria. Sí,
I'm
como
ordering
está.
you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond and put you in jail. If you're not in this country with proper permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody until this case is over with and they get shipped off to immigration. They sleep it daily, hourly. So behave while you're in this country. You get no more warnings from us. Do you understand?
Okay.
If you do not have a Texas driver license and liability insurance, you're also ordered not to drive.
Sí tengo.
I do have.
Judge, it appears that it is eligible.
Parece que sí.
As
Sí,
long as you have a
tengo.
valid license and liability insurance, car insurance, then you will be able to drive. That is also a condition, that you maintain liability insurance.
Es como que me da aseguranza de
Do you have the ability to hire a lawyer?
la capacidad de ocupar su propio abogado.
No.
No.
I can have you fill out an application, but I need to know everything about you. I need to know what kind of work you do, how much money you make, how much money you have at the bank, what kind of car you drive, any other sources of income, and I'll take a look to see whether you qualify. For now, Deputy Miranda's going to give an application. I'm going to have you go to Victoria, sign a reset, and then we'll have you take a seat in the jury box while we take a look at everything. Please.
Just real quick on 13, top of 13, was that state flood conditions?
Yes. Yeah.
Easy. Next judge is page 23, Vera. 25605.
I know, I'm gonna get this sent. Don't be calling me on Monday because I'll be full of to read them.
You are Mr. Vera Quiroz.
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, an officer responded to a call for service for a possible failure to stop and give information in Harris County, Texas. The witness stated to the officer that he observed the defendant strike a maroon four-door sedan from behind, drive around the vehicle, and then drive away from the scene without stopping to provide any information. The witness followed the defendant and observed the defendant to increase and decrease his speed frequently, fail to drive in a single lane of traffic, and nearly strike other vehicles until his car became disabled on Highway 249. The witness observed the defendant to exit the vehicle and to be the sole occupant and operator of the vehicle. The officer made contact with the defendant and observed a strong odor of alcoholic beverage, glossy bloodshot eyes, and poor balance. The officer detained the defendant, and while removing a pocket knife from the defendant's pocket, the officer observed a bulge and a plastic feeling in the defendant's pocket. The officer observed a faint odor of marijuana, so he removed the plastic bag, which did in fact contain a usable amount of marijuana. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 5 out of 8 on the walk and turn, a 1 out of 4 on the one leg stand. The DIC audio was played for the defendant, and the defendant agreed to a breath test, which yielded a .148 and a .143.
Now we've got a hit and run, DUI, and marijuana possession all in one messy bundle. That's not a traffic stop, that's a jackpot for prosecutors. But here's the kicker, 2 ounces is right at the line for a felony in some states. Texas, they're not lenient.
Case, I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. With you, I'm going to test you 50 days from today. If I find that you continue to use marijuana, I will revoke your bond and I'm going to put you in jail. If you're not in this country with proper documentation and you go to jail and immigration finds you, they will put a detainer on you because they sweep it daily. Do you understand?
¿Lo entiende?
Yeah.
Yes.
You are not allowed to drive if you don't have a Texas driver license and liability insurance. That is also a condition of your bond. You do not have a license, you will be signing an affidavit with me today. Mr. Vera, in this short life that we have, do not drive, because if you do, you will pay dearly. Do you understand? This is a promise that you're going to make to me, that you're documenting that you're not going to drive. Nothing you say can justify driving at all. Do you understand?
Yes, sir.
If you get a license and insurance, come talk to me and then I'm happily will take this off. But until that point, you do. Do you have the ability to hire a lawyer? How old are you, Mr. Barrett?
Almost.
No.
23?
Do you work?
Yes.
Do you have the ability, do you have the funds to hire a lawyer?
No.
If you want, I can give you an application and you can apply for a court-appointed lawyer. I need to know everything about you and I'll see whether you qualify. Above all else, do not use, because it's really not going to go well for you. Do you understand? Okay. Deputy Miranda's going to give you an application. I will have you go to Victoria Center Reset. You're eventually going to meet with pretrial services for your bond conditions. After that, we'll take a look at your application. Come on.
One more.
Hey, Glossa, you're earning, huh? You're doing great.
The bottom of page 8, Judge. I don't know how to say that.
You are Arthur Mukes. Mr. Mukes, you're charged with resisting arrest, facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Please.
Thank you, Your Honor. A law enforcement officer was dispatched to a disturbance call on April 19th, 2025 in Harris County, Texas. The officer observed the defendant to be outside of the residence with what appeared to be an injured hand. The defendant stated he injured his hand while punching a wall when he was in an argument with his wife. The defendant stated that he had been drinking Crown and requested medical attention to the scene. The officer attempted to make contact with the female at the residence who refused to open the door. She only stated that the defendant should not be there at the residence and that she was in fear of the defendant. The defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. The officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as the officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, the officers attempted to place the defendant in custody.
Resisting arrest for over 7 minutes. That's not just resisting, that's auditioning for the world's worst decisions highlight reel. But he claims he was the victim who called for help. So, was this an overreaction by police, or self-sabotage under the influence?
As he refused transport. The assistance of 4 officers was required to place the defendant in a patrol vehicle. The officer notes that the defendant actively resisted for 7 minutes and 13 seconds.
Mr. Mukes, I'm gonna find that there's probable cause to go forward. Now's not the time. I know you're itching to say something, but look, I've got a bunch of prosecutors here. I don't want you to say something that hurts your case. Stop. Resist all attempts. If you want, I can give you a lawyer today, and you can give your side to the lawyer, okay? But right now, don't. You're only hurting yourself more when you think you're helping. Don't. I'm trying to help you here, Mr. Mukes. The only condition I'm placing on you now, you're not allowed to consume alcohol. Do you understand? If I find that you're using alcohol or illegal drugs, I will put you in jail. Just don't use, okay? Do we know if she wants to have contact with him?
Judge, the offense date was on the 19th. We have not been able to reach out with the complaining witness yet.
So let's do this. I'm gonna have them reach out. I wanna know if she wants to have contact with you. If she's okay with it, then I'm gonna allow it, okay? Just don't. So we're gonna try to do work on our side or their side to see if they can reach out to her and see if she's okay with contact with you. So, let me see.
Morales Vega?
Okay, so hey, do you mind reaching out to the MAC for Mr. Mukes? I'm gonna get you a lawyer here pretty soon. I'm gonna have you sign a reset with Victoria. We're gonna have you take a seat in the jury box. Just look. Just don't. All I'm asking you to do, man. Okay?
I was the victim here and
I know there are two sides. Mr. Mukes.
I'm the one who called them for help and they locked me up and violated my rights.
Hey, Mr. Mukes, there will be video. We will take a look and we'll see because the evidence is going to point to whose side's correct. I don't know. I wasn't there. Stop. Don't. Please. Good morning, Mr. Ramirez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained and the defendant's blood was drawn.
May I respond?
Please.
Okay, first of all, Judge, the reason, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knee, so he can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying,
I mean, I was actually thinking about that as well. All you have is an odor of alcohol.
This one's fascinating odor of alcohol alone usually isn't enough for probable cause unless paired with other signs. Here, the defense points out no slurred speech, no bloodshot eyes. Just smell. This could be a rare DWI dismissal in Texas.
Is he alcohol because of the tattoo?
Is he what?
He just had a tattoo put on. That's just going to, so that's the odor of alcohol.
Come on, man.
That's what, no, that's, I'm just saying. I mean, that the officer actually asked him that question.
What are they, the little alcohol that you put on your skin, you're telling me that?
I don't know how it works, Judge, but I've never had a tattoo.
You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of an alcoholic beverage emanating from the defendant's breath as he spoke.
Yeah.
That's
it?
all we have before we initiated the standardized post-sobriety test.
Okay, that's not enough. All right, I'm gonna find no probable cause in your case, Mr. Mears. You know, we have enough death on our streets now, you know? $40, one button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Thanks, Frank. You are Mark Ramirez. Mr. Ramirez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 18, 2025, in Harris County, Texas, an officer observed a motor vehicle stopped in the right lane of traffic with its hazards on. The officer approached the motor vehicle and observed the defendant to be asleep in the driver's seat. The officer parked his motor vehicle in front of the defendant's vehicle and attempted to wake the defendant up. Once the defendant was awoken, he allowed his motor vehicle to roll forward and strike the officer's vehicle. The defendant then turned the vehicle off, but failed to put it in park, leading the motor vehicle to roll backwards and strike.
Sleeping at the wheel is dangerous enough, but rolling into one police car, then another, that's a slapstick DUI scene in real life. And refusing sobriety tests before suddenly wanting to do them later, that's like declining dessert and then asking for the whole cake.
Oh yeah, over and over. The officer observed a strong odor of alcoholic beverage emitting from the defendant. The defendant declined to participate in standard field sobriety tests initially. Once the defendant was transferred to jail, the defendant stated that he